who is facing charges in connections with a killing spree where he accompanied his father. And the question is, did he assist and did he commit the actual killings? So we are on verdict watch for that, a very big day in that trial, which we've been following here for weeks. So right now I am joined by Kenneth Belkin, who was with me yesterday discussing the Campbell trial. He's a criminal defense attorney and a frequent guest here on Law News Network. Thanks for being with us.
Thanks for having me, Amy.
So let's get to Campbell first. What do you expect from the jury today? Do you think there will be a verdict?
I think there's going to be a verdict today. It may not happen, maybe late morning, early afternoon. If they come back quick, that's probably not a good sign in my experience. That means they didn't have to deliberate much. They really had an inkling of where they were going before they even got in the room, and that's usually tends towards guilty.
There are a number of charges which we discussed yesterday: the lying in wait, the felony murder rule, potentially second-degree murder. How does that affect deliberations? Is there any correlation between how many charges and how long the jury deliberates?
Yeah, because they have to deliberate on each charge, and each charge has a set of elements that the state is compelled to prove beyond a reasonable doubt. So they're going to have to deliberate on each element of each charge. But sometimes they go pretty quick. It might be as simple as checking it off the list. But I think it's going to be very interesting. Before the prosecution, or at least the first prosecutor, the female one, gave her closing, I would have said they probably are not going to get him on first-degree murder. But her closing was very strong. Their argument was very compelling. And it speaks to the fact that there were probably two assailants.
In contrast to the defense, who we both agreed was not really that convincing.
Yeah, it was very milquetoast, very lackluster.
Milquetoast, I like that word. Why don't you define that for some of our viewers who,
well,
who
we're
don't
not
have
on
the encyclopedia?
We're not on the vocabulary network. We're on the Law News Network. But
can you spell it?
Yeah, I'm going to plead the fifth on that one.
Okay.
But I will say, the closing of the defense was particularly weak. I didn't feel the love.
Yeah. I get milquetoast. I feel like somebody's drunk on milk. Is that what it means?
Plead the fifth.
Okay, listen, so when the judge was going through the jury instructions yesterday, something very unusual happened. A juror actually got up and asked, what is the difference between first-degree murder and second-degree murder? First of all, have you ever seen something like that happen at that point in the trial?
No, the jurors are not supposed to get up and speak in court unless, obviously during jury selection, they're voir dire, they're asked questions, and they're permitted to speak there. But they're really not permitted to speak after that point unless one of the sides decides to poll the jurors post-verdict.
Right.
It's very strange. Typically, the jury would go into the jury room, and what they would do is, if they had a question, they would write it on a piece of paper, the foreman would sign it and submit it to the judge. Judge would read it aloud in court to both parties.
What does that tell you, if anything, that question?
That maybe that juror was drunk.
Okay, on milquetoast.
On milquetoast. So.
No, but I mean, that's a telling question, especially in the context of what we were talking about yesterday, where we both felt that there's a high likelihood that they could convict on second-degree murder, not first, for a variety of reasons. Do you want to go over some of them?
Yeah, I mean, I think the felony murder rule really comes into play. Clearly, there was a burglary. Clearly, he was involved. I think they've got him there. The second degree, I don't know that he intended or there was premeditation. Of course, the prosecution is going to argue that some of the steps that Eric Campbell took would indicate premeditation, such as the taping of his shoes to avoid getting chemicals in there.
Yeah, and with felony murder we were talking about, we think that's the most likely charge that he would be convicted on because you just need the intent for the underlying burglary to get that conviction, and that's sort of easy given the facts of the case. But as I said yesterday, what happens very often is under felony murder, juries are sometimes hesitant to convict somebody on the highest charge, and they'll instead go to that second-degree murder charge because it's hard to wrap your head around holding somebody liable for killings if they didn't commit the actual killings.
Yeah, I mean,
in a premeditated way.
Felony murder rules. It's a little bit of a weird thing to wrap your head around. I remember in criminal law in law school, it was one of those concepts that I think students tend to struggle with a little bit more than other ones. But I will say this, The burglary happened. He was clearly a part of it, and it doesn't take such a logical leap to say that someone can die or be killed as a result of a burglary. It's a particularly violent crime.
Is there a difference between finding him guilty on the felony murder rule under second-degree murder and separately finding him guilty on the second-degree murder charge as a lesser included charge?
I think if with the second-degree murder, that's really saying that he played a part in the killing, so it might affect the judge at sentencing. The felony murder rule is just saying, look, he participated in this burglary, he didn't intend for anyone to die, but 2 people did die as a result of this felony being committed. I have a feeling, though, it's very interesting that they're asking the difference between second and first degree. They're definitely going to struggle with that, so the deliberation may take a little longer than is typical.
Tell us the difference real quick.
Well, first degree, you have to prove premeditation and intent. And premeditation is more than intent. It's that you took some very deliberate, very planned steps in the lead up to the murder that show that this was calculated and this was planned. So I do think that the taping of the shoes, that might be a stretch to prove premeditation. But I mean,
is there anything else really that supports premeditation?
I mean, the amount of weapons they had, the fact that they might have, stalked these people out a little bit. I don't know.
So you're not buying the camping claim then, that they had a crossbow because it's something that they had used in the past on their trips?
I mean, maybe they've used it on their trips, but they used it on this trip in a pretty vicious way.
And what would the lie be for?
The lie.
I'm not a camper. Is that something that you use on camping trips? Lie and spray bottles?
As a rule, I don't go anywhere where sushi isn't readily available. But, that's just me. Look.
Or pinstripe suits.
Yeah, you can't wear one of these camping. I mean, I guess you can. It's not optimal. But
yeah, you don't strike me as a camper, Ken.
No, I'm not a camper. Look, I also don't know that the taping of the shoes shows premeditation. The crossbow, yeah, it's a hunting thing. There's a logical way to explain that away. The sword, though?
Yeah, a sword. That was bizarre.
What do you expect to encounter ninjas in the woods of North Carolina?
You never know.
Yeah, you never know, I guess. But a lot of suspicious things. And the thing that was used to crush her skull, right. I mean, they were loaded up with weapons. They were ready to rock.
I mean, when you put it that way, first-degree murder, premeditation seems a little bit more likely to me then.
Maybe, but I do think that some of those things that the prosecution brought attention to as factors that would indicate premeditation, a lot of them can be explained away to the point where it'd be a bit of a stretch to get to premeditation.
Right.
But her closing.
Yeah, her closing was fantastic.
So strong enough that I left here thinking, wow, first degree is on the table.
Yeah, you were probably having dreams of the Southern accent, which you were so fond of.
Yes, it was a wonderful accent.
That excited you. Now, first-degree murder, let's parse that out a little bit. So you said it requires premeditation, that intent, the planning, the deliberation, basically. But just so everybody understands, they can also get the first-degree murder just under the felony murder rule by proving that he had the intent to burglarize only, because that intent will transfer over to first degree.
Yes, but they don't get the premeditation there. I don't think the jury's going to go.
But they can get a first-degree murder without proving premeditation.
Yes, and they need the first degree to get the death penalty, which I also don't think he's going to get the death penalty. I would be very surprised if they give him the death penalty. I think there are a lot of mitigating factors. He clearly was the victim of some terrible abuse in his formative years, and this definitely affected his mental capacity later on in life.
Right. The question is to what extent. But do you think that the jurors will even understand that they can find him guilty of first degree or second degree without even proving the intent necessary, just by proving that he intended the burglary because of the felony murder rule? Or is that just way too confusing for people?
I think that's a little confusing for them. I think they're more likely to find him on first degree on an emotional basis. I mean, this elderly couple, they're the cutest thing I've ever seen. And the way they were brutally murdered, that strikes a chord with everyone. How
frequent is that, though, that jurors will rule based on emotion rather than the black letter law of the law and the statute?
I think...
Because we've seen in a lot of controversial cases, like the George Zimmerman, or other cases where the verdicts surprise people, and we hear from the jurors after. I remember in that case, jurors saying, listen, emotionally I wanted to rule one way, but I had to follow the law as it was explained to me, and the facts just didn't meet the elements of the law.
Yeah.
And that's pretty impressive also for jurors to be able to stick to that when they have no legal background.
Yeah, that's a remarkable accomplishment and a strength of our system, but I don't like to overplay that strength. I do think there is an emotional role, and people have an unlimited capacity to rationalize their decisions and say, look, we're following the law. One person can look at a set of facts and say, look, I'm following the law, and rule one way, and one person can look at a set of facts and give a totally opposite verdict and say, look, I was following the law.
That's
so people
true.
hide their emotions behind that a lot.
Well, we just saw that in the Bellabon case, where Bellabon's mother's boyfriend was convicted, even though really the only evidence against him was the testimony of the mother, who was also involved.
And had a strong incentive to fabricate testimony because she was given a sweetheart cooperation deal.
Exactly. And so do you think that was an emotional verdict because there was a baby involved?
I do, to some extent. I think that's, just like an elderly couple getting murdered. Like if this was some guy in a gang on the streets of Chicago getting murdered, I'm not saying it's not a terrible thing that this person got murdered, but you don't feel as bad for that person as you do for some elderly couple that was just sitting at home when these two terrible human beings happened upon them, or Bellabon, an innocent child that never harmed anyone.
Right, you're right, because the elderly and babies always strike
They're
a chord with
in our
people.
society.
Yeah, because they're the most vulnerable, generally speaking. So let's head over now and talk about the Gaspard trial. So that's going to unfold today. 13 charges seems like a lot. Why so many different counts of aggravated vehicular homicide? I saw there was a felony 1, a felony 2, a felony 3. I know one portion is probably because a peace officer was involved.
Yeah.
It's a state trooper. Can you explain how that works?
Well,
versus just hitting anybody else?
When you hit an officer of the state, of the government, particularly a police officer, it's an aggravating factor, and in most jurisdictions there's an additional charge specifically for that, because we really want to, the incentive is to provide a safe environment for these actors of the state to perform their job duties in. And we really don't want them to be put in, we really want to let people know, look, you kill someone, that's terrible, and you're going to be punished. But if you kill a police officer, you're going to be punished that much more, because these people serve and protect the community.
Right, so they're putting their lives on the line every day. And in fact, in most states, it's an aggravating factor for the death penalty.
Yes, it is an aggravating factor for the death penalty.
But the death penalty wouldn't apply here.
No,
why?
No intent here, really. Really, he was acting they're going to argue he was acting in a negligent fashion, a reckless manner, particularly because, number one, he was speeding. He was going 78 miles per hour. And as you noted yesterday, a lot of us go 78 miles per hour.
When you're on a highway, depending on how much traffic's on the highway, and I'm not justifying it, I'm not saying I do it, but a lot of people are not going 55 miles per hour. I mean, the speed limits vary, but 70 to 80, unfortunately, has become the norm in a lot of cases.
Yeah, look.
But he was also swerving.
I'm going to go out on a limb and say you do it. And I'm also going to say so do I at times.
I object.
Well, this is your courtroom, so. But look, that's reckless. If the speed limit's 55 or 60.
I speed like you camp, Ken.
Well,
I speed on your camping trips.
I would speed away from those camping trips. But look, 78 miles per hour, that's a significant jump above the speed limit. It's potentially, 20, 25 miles over the speed limit. And
on somebody's tail, swerving in and out and right up on a car. And because that car in front of him stopped or was about to slow down or stop in some fashion, he was right up on it. That's what caused the swerving, which led to the death. Yeah.
And look, also, there are reports that this man was a former drug addict. He was receiving methadone treatments, and he had just received a methadone treatment. So I'm sure they're going to play that up and say, look, not only was this guy speeding, but he was speeding while on methadone, which, some people are of the opinion can affect your motor capabilities.
This is a very controversial point, though, and it's going to be a huge point in this case, in my opinion. Do you agree?
Yeah, because the research is not totally clear on whether methadone affects your motor function. They do say it affects psychomotor function, which slows down the decision-making process in the brain and can have some effect on the nervous system. But it's not clear if it affects your reflexes the way alcohol does or heroin does.
And so because of that, I wonder if there's even a warning on the package to not drive. Would that make a difference? Even if the research isn't there, if the package warns to not operate a motor
Yeah,
vehicle.
I mean, I'm sure they probably warn you not to
just
operate
out of an
a motor,
abundance of precaution.
because they don't want to have any litigation down the line, the makers of methadone.
But putting someone on notice of that and having him drive regardless with that warning, does that play a role at all?
Yeah, it shows reckless behavior. It shows that he was negligent in operating his motor vehicle.
Because obviously he's not a scientist, so he's not sitting there debating whether the warning is valid or not.
If he was a scientist, I'm sure he would have lost his license to practice science a long time ago.
And in fact, he was driving without a license.
Well,
to pick up on your point
add
there.
insult to injury.
Yeah.
And I believe he was on parole from a 2014 conviction in Alabama, where he did the brilliant thing of selling drugs to undercover officers.
That's right. So he was paroled. So how does being on parole and now facing 13 charges, how will that affect his sentence?
Well, it's an aggravating factor. Certainly, his sentence will be longer if he is convicted because of that. Also, you know, he has the issue of he's got this conviction. So if he wanted to testify at trial, this is going to be something that's ripe for the prosecution to cross-examine him on his prior conviction. And nobody likes their client having to say to a jury, answer the question, have you ever been convicted of a crime? Yes, and go into detail about selling narcotics to undercover officers. Doesn't paint you in a good light.
Right, but obviously his attorneys are going to do everything in their power to try to keep that out. And
Yeah.
what do you think their justification will be?
That it's unduly prejudicial. Look, as long as he doesn't take the stand, they won't be able to get it into evidence. They won't be able to open the door to it. The only way they could open the door to it is if he were to take the stand on direct. They could, you know, walk through the open door on cross-examination.
Do you think there's really any reason for him to take the stand in a case like this?
If he was my client, I would strongly advise him not to take the stand.
Why?
The prior conviction, his history, the fact that he was on methadone, that he had prior to that been a drug addict, and well, in all, you know, he still is an addict, but he's receiving treatment.
He's
for that
a recovering
addiction.
prescription drug abuser, yeah. And so on top of what you had mentioned where he was caught selling to undercover cops and he was out on parole on that, he also had prior convictions for drug possession, theft or aggravated theft. So really all of these could aggravate the sentence that he gets if he's convicted.
Oh yeah, he's
because if
he's
you
a
have
persistent
multiple
offender.
offenses, right?
Yeah.
So how much is it all taken as one bundle, or does each offense affect the sentence and potentially elevate it?
It's the felony convictions that will really elevate it, because most jurisdictions, you know, the more felonies you have, the greater the sentencing latitude that the judge has. You know, so I would hope that, you know, when he does get sentenced, he's going to get sentenced on something. He's going to be convicted of some of these charges. 13 charges. Prosecution probably overcharged.
It sounds like a lot. What would be the reasoning, besides that aggravating factor of a peace officer? Why would they tack on so many charges? I mean, obviously you have a driving under the influence, so do you think they put that in as a strategic move to try to emphasize that the methadone affected this?
Yeah,
this
that's what
accident?
they're going to argue, that the methadone affected his motor functioning abilities, and they're going to introduce all sorts of evidence and research that says that you shouldn't drive on methadone, it affects your reflexes. But there is a pretty significant body of research on the other side of that. So we might have a battle of the experts in this one.
I think the question for me, and I'm looking it up, methadone is a Schedule II substance under the Controlled Substances Act. So depending on how they define driving under the influence, because I know what happened with Tiger Woods. Tiger Woods said I was on prescription drugs, and a lot of people think driving under the influence is alcohol, but it's not. It's also controlled substances in a majority of jurisdictions.
It's also harder to measure that. With alcohol, you know, we have the breathalyzer, the old Intoxilizer 9000. And you know that thing will measure your breath. There's a lot of people that question the reliability of that test, but
that's
you know,
basically like an ignition control.
It's something that they'll give you. You know, they give you the portable breath test at the scene when they pull you over. And then they take you back to the station and they bust out the Intoxilizer.
Oh God!
And
really,
you know,
what is that? That's like a contraption straight out of Wizard of Oz, right?
Yeah, it comes out. It says, "I am the Intoxilizer." Yeah, it's like it's some real science fiction stuff. But you know, they give you that at the station, and they get a reasonably accurate reading. Some people contest the accuracy of it, but they get a reading. For methadone, there's no breathalyzer. There's the blood test.
Right.
They have to take your blood. So if they don't have his blood, you know, all they've got going is the fact that he says he was on methadone and maybe the records from when he took it.
Yeah, well, it says he failed the on-scene sobriety test. Can you...
Like a field sobriety test.
Yeah, the field. So, the nystagmus test. Do you know what that is?
You're going to tell me, I'm sure.
I think it has something to do with milquetoast. No, I'm just kidding. The walk and turn test. We know what that is.
The walk and turn
Obviously,
test.
walk the line.
My intern, Erin Cole, would fail that test while sober every time.
She's just not coordinated?
Well, she's very athletic, but she's not particularly coordinated. At
Okay.
least that's the reputation my other
Okay, so
intern
what
is
you're
giving
doing
her.
is saying it's perhaps not a reliable test.
No, look, I mean, follow the pen, walk a straight line. You know, depending if I've had my 4th cup of coffee, I might not be able to walk that straight line.
The finger to nose test, that's pretty easy.
You got
a problem
you do that?
if you can't do the finger to nose.
You got to get the stretch.
Right. And then the one leg stand, that, I don't know. Sometimes I lose my balance on the one leg stand.
Got to get you in some yoga classes.
I know, it's true, it's true. Now, the defendant, though, made statements to the police. They didn't record or write the statements. This is always mind-boggling to me. In this day and age, every trial, the strategy of the defense is to challenge the statements that were made to police. Why don't they record every single statement rather than leaving their officers open to credibility issues on the stand? In terms of, did you remember that? Why didn't you write it down? I mean, we know the memory is not a reliable source.
Yeah. We try to get people, they try to get people to sign their statements nowadays, but I think we are moving in the direction of all statements being introduced should be recorded. The technology is readily available. There's really no excuse why they aren't recording the statements. But I think on the other hand, a lot of statements are said off the cuff. You may not be ready. People will say things, in the back of a cop car, while the cop's driving.
Yeah.
But, the statements, they're always a problem. People are under this mistaken impression that when they're being arrested, they can somehow talk their way out of it. And the cops, they're allowed to lie. They can say whatever they want to you to get a statement out of you. They'll say, oh, we're trying to help you. If you just tell us what happened, we'll let you go. They're not letting you go. You should never make a statement. In fact, the only thing you should say is, I would like to speak to my lawyer.
Spoken like a true criminal defense attorney.
The statements, people
advice,
have no idea how damaging
important.
statements are.
Absolutely. Even this, give me an example of the most innocent statement that could be held against you.
I mean, you could say, they find a dead body in your room.
Right?
I'm sorry, I didn't kill her. I'm sorry, we got into a fight. Oh, I'm sorry, we got into a fight.
Or even just, I'm sorry.
Yeah, I'm sorry. Let's just use I'm sorry.
Be damaging?
Yeah, I'm sorry. I didn't kill her. No, take out the I didn't kill her. Just I'm sorry.
Why would you be sorry if you didn't do anything wrong? That's
exactly
what I would say, right?